The court is civil action number 2483 CV00692, Paul O'Keefe, individually and personal representative of the estate of John Joseph O'Keefe III et al. Versus CNC Hospitality LLC et al. Your Honor, we have the parties present by way of Zoom. We have Attorney Diller for the plaintiff. We have Attorney Beaton for defendant CNC. We have Attorney Tang and Attorney Bell and Attorney Seligson, Attorney Rosenberg and Attorney Jackson present on behalf of Attorney Reed. Defendant Reed.
Good afternoon, counsel.
Good afternoon.
So, to Attorney Diller and Attorney Seligson, a couple of general points. I purposely did not ask for you to provide me with the email in question so I could have the benefit of argument without knowing its content. However, to decide the issue of possible preclusion of any future use of the email for impeachment purposes, I think I will need to see the email. So I'll ask Attorney Seligson to provide to Clerk Donovan in a sealed envelope a copy of the email.
That's fine, Your Honor. We'll do that right away.
Okay, next, let's dispense with any back and forth on what the rules of professional conduct and claimed impropriety on the part of Attorney Diller. Attorney Seligson, I think your one Superior Court decision may not constitute sufficient case law for an attorney to understand their obligations under these unique circumstances. And let's all agree that the circumstances here are unique, just like they were in the Charm case. We can all agree that inadvertent disclosures usually involve an attorney producing in discovery a document that should not have been sent out. In this case, the disclosure involves a client. And Attorney Diller, let's also be aware that I see no reason not to credit Attorney Seligson's affidavit about blind copying his client being a one-time event. So what I see to be the questions here are, like Charm, whether Ms. Reed has shown that she and her counsel took reasonable steps to preserve the confidentiality of the communication, and two, even if the answers to interrogatories in the inadvertently shared email don't provide plaintiffs any additional areas of impeachment, as suggested by Attorney Seligson, what if future sworn statements of Ms. Reed in the email do? So let's try and tailor your arguments accordingly. So Attorney Seligson, it's your motion, so I'll hear from you first.
Thank you, and I appreciate the opportunity, and I think you synthesizing the issues really will cut to the chase here. You referenced the Charm case, Judge, and of all the cases that there are on inadvertent disclosure, and there are many in Massachusetts and there are many around the country, the Charm case could not be more on point. Judge Fabricant faced the exact same issue.
It's probably the only case about a client inadvertent disclosure in Massachusetts, right?
That is correct, John. I was not able to find anything else where, as you said, it's normally the lawyer who includes something in a batch of documents, or an outside service has included something in a batch of documents, and the lawyer on the other side of the case gets that inadvertent disclosure. Here you have, in the advent of digital communications, you have an attorney in Charm emailing opposing counsel, copying his co-counsel, blind copying his client. The client gets the communication, intending only to respond to his lawyer, writes back to everybody through a reply all. Judge Fabricant explains how that can happen to anybody. And what she does is she analyzes whether or not the lawyer and the client acted expeditiously. And she uses the word, use maximum effort to recognize the error, address the error, try and reclaim the communication because it was not a voluntary disclosure. In that case, Judge Fabricant granted the motion to strike that email, agreed that there was no waiver because the lawyer, even though he had done that once before, he had blind copied his client and the client had replied all. And even though the lawyer in that case simply asked the receiving lawyer to delete, destroy, and not use the email, did nothing more. Months later, that email is attached to an exhibit, to a motion for summary judgment opposition, and suddenly the lawyer thinks he needs to move to strike. So the email really wasn't reclaimed in the same way we have done, in stark contrast to that case and those facts. I've sworn in an affidavit which you credit, Your Honor, and I appreciate that because it's sworn under oath, and I stand by it. This is a one-time event, one-time incident where Ms. Reed was blind copied. Inadvertently, she replied to all, not intending for anyone but her counsel to get that reply. That squares with Charm. Immediately, my colleague Aaron Rosenberg reached out to Mr. Diller. That was 39 minutes later. Recognized there was a reply to all, recognized there was an inadvertent disclosure, demanded that it be deleted, destroyed, and not used. Mr. Diller said no, or didn't respond. I then reached out 44 minutes later, confirming, delete it, confirm you've deleted it, don't use it, confirm you're not going to use it. Same thing, trying maximum effort to reclaim the privilege, to reclaim the inadvertent disclosure. We then had back and forth with Mr. Diller for a number of days. He refused to comply with us. We then served a motion. So we used the maximum effort. There was no pattern of behavior like this that you saw in Charm. There was maximum effort to reclaim it. So when you look at Judge Fabricant's analysis of the efforts by the client and her counsel, that we've done even more than Judge Fabricant allowed in granting the motion to strike. This is, by Attorney Diller, an opportunity which is evidenced in his opposition to our motion, Your Honor, where he actually goes so far as to make a sweeping allegation that he says that Ms. Reed and her team, in all likelihood, by her direction and or recommendation of counsel, has been blind copied on all email communications with opposing counsel since the outset of the lawsuit. That is an outrageously inaccurate statement. It doesn't even comply with Rule 11, where a lawyer signs his name to pleadings and certifies that he has a good faith basis to make such a claim. What that means is Mr. Diller is trying to take facts that don't exist, create this narrative of recklessness, which does not exist. Ms. Reed was blind copied once, replied all once, and trying to fit that squarely in to get around what Judge Fabricant says in her opinion, which is lawyers should not take the opportunity to use something like this as an inadvertent disclosure and take advantage of that. Your Honor, for the same reasons in Charm, you should rule that there was no waiver of the attorney-client privilege here. This was not a voluntary waiver. This was an inadvertent disclosure. This fits squarely with Charm. We've done more than the lawyer in Charm did. We've acted faster than the lawyer in Charm did. We've proven there was no pattern like there was in Charm. And Judge Fabricant still understood the importance of the most sacred of privileges, the attorney-client privilege, and did not allow those facts to erode it. And we asked you to reach the same conclusion, Your Honor. Regarding the impeachment value of this email, we'll provide you the email in camera as you have ordered, and you will see that it squarely fits with everything Ms. Reed has answered in the second interrogatory that was posed to her. So it has no impeachment value. The plaintiff's attorney was asked to return it. There's plenty of discussion in the rules of professional responsibility in the case law about returning an email that's been inadvertently disclosed. Judge Fabricant speaks about, to quote her, she says, as a matter of courtesy and in recognition of their own vulnerability, lawyers should avoid the temptation to seize opportunities arising from inadvertent disclosure. It's just, this should just end today. Mr. Diller should not be permitted to use it. He should not be permitted to disseminate it, and it should be destroyed. We've done everything we can to reclaim it, and I rest on those cases, Your Honor.
So you argued in your papers, and you just argued now about impeachment relative to the answer to interrogatory and the email. But what about in the future, if there were some statement under oath by your client?
Your Honor, there will not be a statement under oath that the email can be used for impeachment purposes. Mr. Diller,
we hope not, because we're all, as lawyers, tell our clients that they can't commit perjury, but not all our clients listen to us all the time. At least my clients didn't always listen to me. So just the possibility of that in the future.
I understand, but I think that answer will be very clear for Your Honor once you see what is in the email and you compare it with what is in the interrogatory answers. I have to tread lightly because I don't want to say anything about the email, but you will see that once you read the email and you compare it with the interrogatory answers, if there was something inconsistent with the interrogatory answers, then sure, then Mr. Diller can use that for impeachment purposes. But the email itself has no impeachment value once you look at it with the interrogatory answer. There have been 2 interrogatories served on Ms. Reed. The second one asks her, and we suggested that to Mr. Diller because we were going back and forth about whether or not her first interrogatory answer he thought was needed clarification or expansion. So we suggested to him, ask another interrogatory about stating the basis for the affirmative defense in the answer to the complaint, which states somebody else was responsible for the death of John O'Keefe. In response to that interrogatory answer, we have, with Ms. Reed, assisted her, and she has signed her interrogatory answer that is consistent with what's in that email. So there's no impeachment value. He can use the interrogatory answers. What we're trying to avoid is him making the argument that somehow she has waived the privilege and he can use the email. There's no basis for it, and I think the in-camera review will answer that question squarely for you, Judge.
Okay, thank you. Attorney Diller?
Your Honor, thank you. I want to address, first and foremost, what was just raised, which is the reply brief. I think it's noteworthy that counsel for the defense did not file this motion under seal. In fact, they attached a reply brief that says verbatim, comparing this answer to the privileged communication demonstrates that there are no areas for impeachment unique to the privileged communication. And then they add as an attachment to that email, the answer to interrogatory under oath statement signed by Karen Reed, all of which, given what's happened in this case, has been picked up in the news and become part of the public domain. The law's privilege is waived when its contents become public. Counsel, to the extent that there may have been a privileged communication when the email, to which I did not disseminate, chose to put its contents directly into a public filing and attach the answer to interrogatory to which Attorney Sellison just communicated to you, stands for the same issues and the same facts are live. Now, I appreciate that Your Honor wants to look at this in camera. I would say to you that I'm not really sure why we are here at this point, given that I understand why it was served. I did not disseminate it based on an agreement that I had with them, but I did point out case law why I believe that I could use it to impeach credibility, given that there were other statements that I believe to be inconsistent with that. And then I understand after I served my opposition, why then it would be filed. But I didn't understand why there was no attempt by counsel to seek an in-seal filing of this together with the answer to interrogatory and/or an in-camera on all of it. I feel as if in Judge Fabricant's 2010 order, she's very clear that she says, a client who seeks to preserve the privilege has the responsibility to be careful, particularly when using a means of communication that poses known and obvious risks. Lawyers should advise clients to be careful and avoid practices that exact those risks. And then Fabricant gives a public warning to the bar in general. It says, others should take note. Reply all is risky, so is BCC. Further carelessness may compel a finding of waiver of privilege. That was 16 years ago. The world and technology has advanced. We've all become more sophisticated with the way to deal with it. We were also relying on an MCLE, which was written by a gentleman who was with the BBO, that says an argument could be made that privilege is now waived when a client replies all to something that they were copied on. That just deals with the first issue, which I think the whole thing has been waived regardless of how you interpret Fabricant's decision. But the second issue, as it relates to impeachment, we have the late, great Judge Gantz, who wrote an opinion. We have Justice Kaplan, who both issued opinions. Both suggest you can't unring the bell. I identified that there were inconsistent statements in the email that was provided to me before anybody tried to recall it or advise me that that was intended as a client confidential communication. I then said, I'm not intending to disseminate it, but I do believe an argument's made that she's waived it. And I more so think it's significant that should she give inconsistent testimony moving forward, it certainly has impeachment value, which has been borne out by Justice Gantz, Justice Kaplan, Superior Court decisions to talk about the impeachment value of it. So ultimately, I stand by the position that, for starters, I believe that they have waived the any privilege that may have existed in the communication by publicly disseminating the content of it. And then secondarily, I have every right to use it for impeachment purposes as we move forward in this litigation. Your Honor, I rest on the papers as it relates, or will answer any questions that Your Honor has.
Your Honor, may I respond?
Oh, sure, go right ahead.
Your Honor, the notion that a litigant would be served with an interrogatory, answer the interrogatory under oath, and then somehow be deemed to have waived the privilege is preposterous. What I'm arguing is, for impeachment value, there is none. And once you are able to see the email and compare it with the interrogatory answer, you will make that decision for yourself, I am confident. But if Mr. Diller served us with a motion, and we served him with a motion, and he attached signed interrogatory answers, or we attach signed interrogatory answers that have been served in the normal course, there's no waiver of the privilege. That's just not a valid argument. Second, Mr. Diller cites two cases in his brief, which is referenced today. Those cases actually stand for the proposition that there has been no waiver. The cases that he cites to, the Mirror Inc. versus O'Brien. The court found that Judge Gantz found that there was no waiver of the attorney-client privilege with an inadvertent disclosure. The case that he cites to in his brief, and he mentions as well, this is Judge Kaplan, Vigor Works versus Scansa. Judge Kaplan finds there was no waiver. Your Honor, again, this is desperation. It's an inadvertent disclosure. We've done everything we can to prove to the court under the reasonableness standard that Judge Fabricant lays out in Charm. It's the same fact pattern, same conclusion should be reached. Ask your court to allow the motion that the privilege has not been waived in part or in whole whatsoever, and that Mr. Diller, his clients, and anyone else who has had a look at that email be ordered not to be able to use it. Thank you, Judge.
Okay, thank you. I'll take the matter under advisement.
Thank you, Your Honor.
Thank you, Judge.
Thank you. All this matter is under advisement. This matter has an next date of March 5th, 2026 at 3 p.m. for the Rule 15 conference. Thank you all.